Hello. 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 Am I audible?
Hello, this is from BSUC. Are you,
Yes, sir.
right? My audio videos are clear?
Yes, yes. You're absolutely fine.
Okay, thank you.
Thank you, sir. Good morning. We will begin the session within a few minutes. No.
Renowned astronomer Carl Sagan once said, "For me, it is far better to grasp the universe as it is than to persist in delusion, however satisfying and reassuring." Ladies and gentlemen, distinguished guests and participants, welcome to the 16th International Seminar on the Role of International Law in Controlling Weaponization and Arms Race in Outer Space, organized by Kerala Law Academy Law College in association with the Center for Advanced Legal Studies and Research and IQSC KLA. Today, we embark on an enlightening journey that explores the realms of international law and its crucial role in shaping the future of space exploration and security.
This seminar addresses a critical concern that resonates with the global community. As space exploration and technological advancements continue to accelerate, the potential weaponization of outer space poses significant challenges to international security, peace, and the sustainability of space activities.
Kerala Law Academy Law College, since its inception into the legal hippodrome in the year 1966 by the legal luminary, the late Dr. N. Narayanan Nair sir, has always been a seat of excellence in legal education, consultancy, research, and pioneering law reforms. Through its various programs and events of international and national significance, Kerala Law Academy Law College consistently aspires to push boundaries and is in its constant effort to provide the most stimulating environment for its students to cultivate and display their greatest abilities.
This seminar aims to provide a premier interdisciplinary platform for researchers, practitioners, and educators to present and discuss the most recent innovations regarding the need for space dispute settlement mechanism, about the relevance of sanction and enforcement in existing space treaties.
Before we begin our inaugural session for this event, let us spend a minute in silence to cherish the memory of our beloved late Dr. N. Narayanan Nair sir. Thank you all. So, without further delay, let us introduce the esteemed speakers of this event who will be sharing their knowledge and expertise with us today. We have Dr. Ranjana Kaul, Director of the International Institute of Space Law, Dr. Unikrishnan Nair, Director of Vikram Sarabhai Space Center and Indian Institute of Space Technology, Professor Dr. Sandeepa Bhatt, a distinguished professor of law and the director of the Center for Aviation and Space Laws at the West Bengal National University of Juridical Sciences, and Dr. Banerjee Chaka, the dean at the VIT-AP School of Law, VIT-AP University.
Now, it's my pleasure to welcome Advocate Nagaraj Narayanan sir, Director, Kerala Law Academy Law College, Professor K. Anil Kumar, Director of Administration, Students and Faculty Affairs, Professor Harindran K., Principal, Kerala Law Academy Law College. Their efforts have been instrumental in shaping the success of this seminar. In addition to our distinguished speakers, I would like to extend a warm welcome to our faculty conveners, teaching and non-teaching staff, participants, and every one of you present here.
Now, we have the privilege of having Professor Anil Kumar Ji, sir, Vice Principal, Kerala Law Academy Law College, for the welcome address. Sir has over 25 years of teaching experience and is a constant source of support for all of our academic and co-curricular events. I invite Sir to deliver the welcome address and set the stage for our discussions. Welcome, Sir, to this virtual dais.
Thank you. Honorable guests, esteemed participants, distinguished attendees, a very warm welcome to the 16th International Seminar on a role of international law in controlling weaponization and arms race in outer space, organized by Kerala Law Academy Law College in association with KALSAR and IQSC KLA. We are delighted to have each one of you joining us in this virtual gathering. As we embark on this intellectual journey, it is my privilege to commence this event with a thoughtful quote by Albert Einstein, who once said, "Peace cannot be kept by force. It can only be achieved by understanding." Indeed, the topic of our seminar today is of immense significance as we delve into the realm of international law and its role in shaping the exploration and preservation of outer space. The growing weaponization and arms race in this frontier poses unique challenges that call for our collective attention, cooperation, and legal solutions. It is an honor to introduce our distinguished guest, whose expertise and insights will undoubtedly enrich our understanding of the subject matter. First and foremost, we have Dr. Ranjana Kaul, Director of the International Institute of Space Law and partner at Dua Associates, Advocates and Solicitors, New Delhi. With her extensive expertise in the legal aspects of space exploration, Dr. Kaul brings a wealth of knowledge and expertise to this seminar. She specializes in international air and space law regimes. She is the founding member of India's first independent think tank on space matters, Spaceport Sarabhai S2, launched globally in December 2021. Dr. Kaul is on faculty at the London Institute of Space Policy and Law, UK. She is a frequently invited speaker at limited audience forums, and she speaks extensively at law schools in India and internationally. I, on behalf of everyone present here, welcome ma'am to this function. A hearty welcomes to you, ma'am. Next, we are privileged to have Dr. Unikrishnan Nair, Director of the Vikram Sarabhai Space Center and the Indian Institute of Space Technology. Dr. Unikrishnan Nair is an Indian aerospace engineer presently serving as the Director of Vikram Sarabhai Space Center. Prior to his directorship of VSSC, he was a Director of Human Space Flight Center, Bangalore. He is also currently holding the additional charge of the Director, Indian Institute of Space Science and Technology. He also holds an MA in Telecommunication and Space Law from Nalsar, Hyderabad. As a founding director of the youngest center in ISRO, the Human Space Flight Center, he has led the team for Gaganyaan project and established the Astronaut Training Center at Bangalore in Human Space Flight Center at Bangalore. Dr. Nair's contributions to space technology and research have played a pivotal role in advancing India's exploration endeavors. We are honored to have him here with us today. A warm welcomes to you, sir. Next, I would like to invite Professor Dr. Sandeeba Bhatt B. Sir, a Professor of Law, Director, Center for Aviation and Space Laws, the West Bengal National University of Juridical Sciences. Sir has the experience of researching on 5 major research projects sponsored by World Bank, ISRO, the West Bengal Judicial Academy, Ministry of Justice and Ministry of Environment, Forest and Climate Change. He has the distinction of being the member of the American Society of International Law, Baltimore, United States of America, International Academy of Space Law, Moscow, Russia, and the International Institute of Space Law, Paris, France. He has presented over 125 research papers in the international and national conferences, including the coveted International Astronautical Congress, as well as in various international conferences. I, on behalf of everyone present here, welcome Sir to this function. A hearty welcomes to you, sir. Joining us as well is Dr. Banerjee Chaka, a highly renowned professor of international law and the Dean at VIT-AP School of Law, VIT-AP University, Vijayawada, Andhra Pradesh. He has an illustrious academic background where he has served as British Chevening Scholar at SOAS, Associate Professor of Law and Registrar at National University and Judicial Academy, Assam, lecturer at School of Law, National University of Ireland, Galway. He was a legal advisor to the International Committee of the Red Cross based in Geneva. He was a research associate at the Indian Society of International Law. He is associated as a judge for many prestigious international moot court competitions. He published research articles and books in the field of international aviation and space law and international humanitarian law. Dr. Banerjee Chaka's expertise in international law will contribute greatly to our exploration of legal frameworks surrounding outer space activities. I welcome you to this session, sir.
Thank you very much. Good morning.
It gives me a great pleasure to welcome Advocate Nagaraj Narayanan, sir, Director of Kerala Law Academy Law College and Member Bar Council of Kerala. His visionary leadership and relentless efforts have made this seminar possible, fostering an environment where knowledge and ideas thrive. Extending a hearty welcomes to you, sir. We are also privileged to have with us Professor K. Anil Kumar, Director of Administration, Students and Faculty Affairs, Kerala Law Academy. His invaluable support and dedication have played a vital role in the success of this seminar. I welcome you, sir, to this seminar. We extend a warm welcome to Professor Harindran K., Principal, Kerala Law Academy Law College. His guidance and commitment have been instrumental in shaping the academic excellence for which our institution is renowned. We also have the presence of Professor Ajita Nair L. I extend my hearty welcomes to you, ma'am. We also acknowledge Serin Elsa John, Assistant Professor at Kerala Law Academy and Member International Institute of Space Law. Ma'am is also one of the faculty conveners for this seminar. Her interest in space law is a testament to the caliber of our faculty and their commitment to advancing legal knowledge in this field. I Heartily welcome you, ma'am. Last but not the least, I take the opportunity to welcome our faculty conveners for the event, Dr. Dakshina Saraswati, General Secretary, Kerala Law Academy, Moot Court Society, and Assistant Professor, Sri Shakti Prabha M, Assistant Professor, Kerala Law Academy, and Sri Sajit Sangaran Narayanu, Assistant Professor, Kerala Law Academy. In addition to our esteemed speakers and faculty members, I would like to extend a warm welcome to our faculty conveners, teaching and non-teaching staff, participants, and each one of you present here. Your continuous efforts play a very important role in making this event a reality. We have an exciting agenda ahead, filled with engaging sessions, insightful discussions, and opportunities for networking. Let us make the most of this virtual platform and strive for a fruitful exchange of ideas that will contribute to the betterment of our shared future. On behalf of Kerala Law Academy Law College, I once again welcome you all to this 16th International Seminar. Let us embark on this journey together, united by our passion for international law and the exploration of outer space. Thank you all.
Thank you, Anil sir, for your warm welcome. We also extend a warm welcome to you.
As we delve into the fascinating topic of the role of international law in controlling weaponization and arms race in outer space, we have an incredible lineup of distinguished guests who will grace us with their insights and expertise. We are honored to have Dr. Ranjana Kaul, Director of the International Institute of Space Law and partner at Dua Associates, Advocates and Solicitors, New Delhi, with us today. Dr. Kaul's primary practice includes advising on joint ventures and acquisition, aviation, education, oil and gas sector regulation, foreign exchange regulation, company law, and intellectual property rights. She also advises on issues related to international and domestic laws and regulations about space-enabled businesses. She has also litigated in the High Court of Delhi and Supreme Court of India and other tribunals in related matters. She'll grace us with her presidential address, shedding light on the crucial aspects of international law in controlling weaponization and the arms race in outer space. I welcome you, ma'am, to deliver the presidential address. Ma'am, please. Ma'am, your mic is on mute.
So thank you for the wonderful and kind words by you, Dr. Anil Kumar, for inviting me here, Professor Ravindran, your team, the conveners, all of you here. It's wonderful to see you again. And for sure, you have chosen, I don't think there could be a live topic, a more dynamic topic, even as we speak right here and now. So of course, we know that the weaponization of outer space, the prospects of a treaty to ban or to prevent an arms race in outer space have been subject matter of discussion and in the international statute since 1963, would you believe it? Long before this business of the prospect of weaponization or arms race in the true way in which we are talking about arms race actually has unfolded itself into quite a frightening prospect for the sustainable, peaceful use of outer space going forward, for the prospect of continuance of understanding outer space as the global commons. All of this is under pressure and threat as we speak now. But yes, to get to the topic, international law is foundational for both preventing weaponization and for, well, ensuring, hopefully, a binding treaty on the prevention of arms race in outer space. The international institution where these have been formulated, which is the United Nations, and in the context of weaponization and so forth, it is the Conference on Disarmament, which reports to the First Committee of the UN. It's a standing committee and the Committee on Peaceful Uses of Outer Space, which deals with, of course, all matters related to peaceful use under the 4th Committee, and all of these converge in the United Nations General Assembly. At the end of the day, as much as a foundation has been laid during that particular point in time, it is geopolitics that determines whether a treaty will be in place, will it not be in place, and if it is in place, is it to be put under pressure such? Short point is, international obligations and national interest will forever dictate the future of space. So just to get to the basic, space as a domain is a dual use domain. We know that. The origin of which lies in World War II. The guided missiles, the V2 rockets of Germany, and then the US dropping the atomic bombs on Nagasaki and Hiroshima to secure surrender of Japan. These are the two tectonic events in the last and final years of which has led to the position where we are. The V2 rockets told the army commanders that here is this amazing domain, high altitude, which is a very desirable military domain. It is significant because it is a military domain. That brought us into the space age. Hiroshima and Nagasaki introduced us, the world, to the nuclear age. And thereafter, immediately after the close of the Second World War and the UN in October of 45, both countries, there were only the two superpowers, USA, USSR, established military space programs. And the years between 1945 up until Sputnik were tremendous energy in technological development in both. Hundreds upon hundreds of nuclear tests, thermonuclear tests, developing capability for very superior levels of launch capability. All of this was happening until the Soviets launched Sputnik, the first military satellite. And that triggered a revolution in military affairs, which has had strategic consequences, and we live by it. And remember that this revolution in military affairs is the second revolution in military affairs and world affairs. The first one happened when gunpowder was introduced into terrestrial warfare. And this is somewhere in the 900s, mid of 900s, when the Chinese firstly discovered and made use of it in warfare. So you see, it is weapon systems. Now, here are two nuclear capable states. Here are two states with superior launch powers. And for sure, the prospect of nuclear weapons was completely not something that they wanted to proceed with, because they had not, in their opinion, developed technological capability to the extent that they would have wanted to. And it is that motivation, that expediency that took them to the UN. And then you have a series of UN General Assembly resolutions. The first one was peaceful uses, where first and foremost, all matters, all activities that are not aggressive or offensive are understood to be peaceful. So military use is definitely up on the table under peaceful use. And the aggressive, which is nuclear, WMD, so forth, is removed, and they create two new institutions. So when you fast forward that, the Cold War years were, I mean, one almost feels nostalgic, because the superpowers were actually cooperating with each other. 75% of satellites we know during the Cold War years were for military use. And it is these, the reconnaissance satellite, the surveillance satellite, the photo reconnaissance, all of those superior technologies were the reason why there was peace and harmony, in a manner of speaking, harmony between the two, because they were able to see the technical means of verification. That is what it means, surveillance. It is also supplemented by the 1963, that's the first treaty that was adopted by the UN. Please understand that the partial limited test ban treaty, outer space treaty, registration, rescue, liability, and moon were being negotiated in simultaneous time. Look at the energy of the time, technological development and tremendous use of the organs of the United Nations. And this is what we got. So you got the limited test ban treaty, but the superpowers also supplemented it with bilateral treaties, the anti-ballistic missile treaty, for instance, the SALT, the Strategic Arms Limitation Treaty. When you study this, and when I address all of you students here, you must study all of these documents very carefully to really get the essence of what is happening. So when you fast forward, you then come to 1991, and which is the defining year in my view. First, the year started with the first Gulf War under the senior President Bush. It is the first time that space applications were used in terrestrial warfare. The US armed forces, it had been completely harmonized into the systems, and now this is what unfolded. At the end of the year, the Soviet Union collapsed. And that made a shift from a bipolar to a unipolar world. And although there was some great deal of cooperation and coordination between Russia, which had just emerged as the power and was struggling with the reorganization part of its new identity, there was inevitably national policies that had huge ramifications to space. And by that, I mean, in the 2000s, there has been firstly, starting with the war in Iraq, moving on to the 2007 anti-satellite test, which announces the arrival of China, the tremendous growth and development of China in every which way, and the emergence of Russia, especially starting with the second presidency of President Putin. And now what do you have? What we are going through is the, what should I call it? The birth pangs of shifting from a unipolar to a multipolar world. Now, when China tested, immediately thereafter, the US tested again within months. We, 12 years later, undertook ours. We have regional concerns. And so that ball has rolled on. Today, debris is a very serious issue. So what I would like you to do really is that, without going into too many details, because this is a short narrative, what I would say to you is that when you analyze your treaties, please make sure that you look at the geopolitical context to try and understand what may be the possibilities that might arise. There has been a paralysis in the COPUS. There has been a paralysis in CD ever since the US withdrew unilaterally from the ABM treaty in 2002. So here it is, my sense of it all. When you look at the partial test ban treaty, it is amazing, as I told you, that in 1963, the proviso to Article 1 of that treaty says the intention of the parties for a binding treaty on all types of nuclear weapons, including underground. For those who've read the partial test ban treaty, you know that testing in outer space, on the high seas, the territorial waters, including on ground in your territory, such that the radioactive debris ports itself to the neighboring state, is prohibited. In air, it is prohibited. Underground is permitted. But in 63, they're talking of a binding treaty with the possibility of all kinds of this, which I found amazing. But perhaps the only treaty that I have read, and I'd like to learn from professors over here who would likely know better, is that Article 4 says that the state may withdraw in case of extraordinary event, which in its opinion is contrary to national interest. Now, of course, in all international treaties, there is a clause which allows a country to withdraw from that treaty by giving a certain notice. For example, Saudi Arabia, which is participating in the Artemis Accords, and which has also been, until the recent past, a ratifying state of the Moon Agreement, gave notice and has now withdrawn. But here, the state may give 3 months notice, and the reason could be national. I have not seen another international treaty that explicitly talks about national interest taking precedence over international obligation is the way I'm looking at it in very simplistic terms. This is something that you will have to think about and study carefully about what it might mean going forward. Similarly, when you're talking about weaponization, as much as the Outer Space Treaty Article 4, the ratio of the SS Lotus, has allowed development of conventional weapon systems that, of course, ASAT is Earth to space. We haven't yet had the prospect, although there are murmurs on the subject, of conventional weapon systems being placed in space down to Earth. And of course, as I told you, this business of, the participation, the recent events of the Ukraine war, where you have had a commercial company of one country providing support to one of the belligerents, where the Russians have made a statement in Conference on Disarmament to say that they view that as a legitimate target. I mean, that's taking you into a whole different zone. In the recent past, by recent I mean 2021 November, the Russians undertook a anti-satellite test somewhere close in the vicinity of the International Space Station. This created a lot of debris, and there was, consternation across the world. In December, the UN General Assembly had 4 resolutions that were submitted for consensus, vote in the UNGA. Of these 4, the US has voted against 3. Those 3 are no first placement of nuclear weapons in space, voted against it. Transparency and confidence building measures, voted against it. Treaty, the Paros Treaty, voted against it. The only resolution that was voted in favor of by the US is the establishment of the open-ended working group to reduce space threats through norms, rules, principles of responsible behavior. And this is linked to linked to the Outer Space Treaty. So if you look at the recent proceedings and the submissions by countries before the CD, Conference on Disarmament, you will find that for the most part, it is Article 9, the principle of due regard to the corresponding interest of other states undertaking activities, and then linked to the common interest principle, which is Article 1. And this is how most countries have framed their propositions. What is going to happen going forward? Well, I don't look into the future, so I really can't say. But you must also know that development of new technologies is going to bring new challenges. The 5G wireless technology has already brought a whole new domain, which is now referred to as near space. Which is to say altitudes, which are, let's say, over about 21 kilometers above the surface of the Earth. 21, why 21? Because commercial aircraft fly at around 18 or 19 kilometers and military at 20, max 21. So altitude above, let's say 21 kilometers up to 160 kilometers. Now, why 160? Because 160 kilometers is the lowest stable orbit for satellite systems. And 120 is where, if it's an uncontrolled entry, there could be an implosion and so forth. So when you're thinking of suborbital, think of, Richard Branson and Jeff Bezos. When you're thinking of commercial space transportation, which is suborbital or orbital, you need to be monitoring that whole system. But where you are thinking of 2 regimes which are completely diametrically opposite to each other, the international air law recognizes sovereignty. It's based upon sovereignty. So you have sovereign airspace. And outer space, as you know, does not recognize sovereignty. How will you apply these treaties? These are challenges for lawyers and for professors and anybody who's interested in the matter to discuss. Where this is taking us, I do not know. But in the middle of all this, what you have is human quest to dominate lunar resources, planetary resources. And you have the Artemis. As I told you, big power rivalry is reflected in the UN. there has been a stalemate in the UN in all bodies since 2000. No new regulatory frameworks are coming out of it, with the result that that vacuum is being filled by national laws, national projects outside the realm of the UN. Now, whatever else you may think or not think about Artemis, I urge all of you students to read it extremely carefully and appreciate it in context to the existing treaties, because that is all you have as a reference point. And understand what is good about it and what are areas of concern, if indeed you have any areas of concern. At the end of the day, space is about geopolitics. What happens in outer space starts and ends here on the Earth. And where you say that you have 11 spacefaring nations, of which 3 are the uber space powers, that is USA, China, and Russia. The rest of us who are spacefaring powers are referred to as middle space powers. This includes ESA, the European Space Agency. And with big power comes big responsibility. And that must be discharged by the big states. They are the ones who drive whether there will be consensus or will not be consensus. So I would say that that's a gauntlet and that's their burden. But if indeed space is to be for all, then there has to be consensus. And there is nothing in outer space treaty where you may hate the Moon Agreement, fair enough. Nothing in outer space treaty prevents countries from reaching consensus to arrive at an equitable framework for how lunar resources, when they are mined commercially, how they will be managed. Thank you very much. I wish you all the very best for this wonderful topic that you have chosen. Thank you.
Thank you, ma'am, for your words of wisdom.
We are privileged to have the presence of Dr. Unikrishnan Nair S., Director of the Vikram Sarabhai Space Center and the Indian Institute of Space Technology. He is an Indian aerospace engineer, presently serving as the director of Vikram Sarabhai Space Center. Sir is known for his work in the field of launch vehicle design, space capsule recovery experiment, and human space flight program. Before his directorship of VSSC, he was the director of the Human Spaceflight Center, Bengaluru. He is also currently holding the additional charge of the director of the Indian Institute of Space Science and Technology. Now, I invite Dr. Unikrishnan Nair, sir, to deliver the inaugural address. Sir, please.
Very good morning. Am I audible?
Yes, sir, you're audible.
Yeah, very good morning, Dr. Kanchana Kaul, who is presiding over this function. Professor Dr. Dakshina Saraswati, Professor Sandeep Bhatt, and Dr. Banerjee Chakka, who are all going to talk on this topic. And Ms. Serene Elsa John, all other speakers and audience who are joining online. Very good morning to all of you. And I thank the organizers for inviting me to this inaugural session. All of us know that satellites are playing a very important role in our day-to-day life. If satellite service is not available, we will feel immediately from T0 onwards, we will feel the pinch of it. Probably the first to affect will be the traffic, air traffic. And then within hours, other systems will be affected. Maybe in a few weeks' time, the economy will be shut down. It is not the situation in India alone. It's a global situation. We depend so much on space assets like satellites and other services from space. India too is not different in that sense. You all know that the space age began in 1957 with the launch of Sputnik. And in India, we started the space program in early 60s, thanks to the efforts by visionaries like Dr. Sarabhai and Professor Satish Dhawan. And this is one area which we have not missed the bus. We started in the early phase itself. And we had our early rocket launches like sounding rockets. And in 70s, 80s, we started making launch vehicles that can take satellites to orbit. And now we have our own fleet of launch vehicles like PSLV, LVM-3, GSLV, and the new small satellite launch vehicle. And we are also working on futuristic heavy lift vehicles for future requirements. So it is all the more important that we protect our space assets because we need to ensure that the services are available to our common man or the entire population in the country. But at the same time, we know that there are issues related to space assets and its protection. We also know that the space is the fourth frontier of war. That means if there is a war, if you want to win over another country, the best way is to silence their satellite. So that is how the anti-satellite weaponry and testing program initiated. Can you go and kill a satellite so that the satellite services are not available? Can you have spy satellite that will monitor the activities of other countries' satellite and report back what they are doing? And in case, if required at an appropriate time, damage the satellite and then create a lot of confusion or maybe create a lot of service disruption on ground. And in India, we know that we have a new space policy in place. And also, so the space is now opened up to all stakeholders, private and others. They can become partners through new mechanism like in space and in civil. And it is all the more important that we also give attention to what is the legal aspects of it. Recently, there was an incident where a rocket part of another country was fallen over our landmass. Maybe a very small place, the thing has happened. But we know that there is a liability convention for the rescue of astronauts. There are treaties dealing with such things. Those treaties were started in 60s or even before the first satellite was built because the visionaries were aware that the common heritage of mankind, that is everything beyond Earth, is the common heritage of human race. So once humans go there, definitely there will be race and there will be litigation and sort of thing. That is how the genesis of OST or service treaty as well as rescue agreement or liability convention or even launch registration convention. Each country is supposed to register what they are launching into space so that we have an account of how many satellites and other satellite related things are there. And the Moon Treaty was the last treaty from the UN in 1979. That also we know that it was not well accepted because it speaks about, say, the entire thing belongs to the humanity. Now, from our Indian point of view, this area, that is space law or the related field, we also need experts in that area to argue our case nationally or internationally to understand the vast opportunities of space law. You know that once we cross maybe when we started the space program, it was the 60s and 70s, the manned mission to moon and things like that were probably mostly based on a Cold War or going to space and then proving a point. But now the situation is changing. Now we are, the human race is seriously thinking of migrating to other planets using moon as an intermediary base, going to Mars and have permanent settlement. And the first man-made satellite that has crossed the solar system, Voyager, just crossed the solar system and just reached 0.002 light years away from the Earth. And it is see the expanse or what is waiting for us, like exoplanets and other planets in the other solar system or other galaxies where life is there. So it's a vast resources and other opportunities that are waiting outside there. It's very important that we are discussing a topic where how the militarization as well as our weaponization of space or controlling weaponization and arms race in space is important for both developed countries and developing countries. And I don't want to prolong much of this topic because I know that the experts are here, they are going to talk about it. But in our country, there is the need to have very strong courses as well as academy also need to take up space law as a syllabus and then bring out the best minds, they can defend our cases both nationally and internationally. With this, I am very happy to declare that this inaugural one day seminar for the role of international law in controlling of weaponization and arms race. This assembly of best minds, and they are going to talk and discuss and chart out a future course of action for all of us. I wish all the very best. Thank you.
Thank you, sir, for shedding light on the crucial topic at hand.
Also, we have with us today Professor Dr. Sandeepa Bhatt, Professor of Law and Director of Center for Aviation and Space Laws at the West Bengal National University of Juridical Sciences, Kolkata. Professor Dr. Sandeepa Bhatt started his academic career in 2003 at the National Law School of India University, Bangalore, and joined NUJS in 2007. Currently, he is working as a professor of law at NUJS. He has experience researching 5 major research projects sponsored by the World Bank: ISRO, West Bengal Judicial Academy, Ministry of Justice, and the Ministry of Environment, Forest, and Climate Change. He has also acquired a doctoral degree in the field of space law. His extensive expertise in the field will shed light on the international legal framework governing outer space. I invite Dr. Sandeepa Bhatt, sir, to deliver the keynote address. Sir, please.
Very good morning to all of you. First of all, am I audible?
Yes, sir, you're audible.
And also, is my screen visible?
Yes, sir.
Okay, good. Right, thank you. I should first say that actually it's a delight to see that the Kerala Law Academy has chosen a very, very contemporary topic in terms of aspect of dealing with the weaponization of the outer space. I said it is very contemporary because in the light of the current Russia-Ukraine war, if I have to rephrase that, then maybe the Russia-NATO war, to be very precise. In the context of this, there are a lot of things which are happening in the space. Multiple military activities and even actually the aspects of weaponization are going on in the sector of the outer space. So that's the very reason why I should say that this is really a contemporary topic for discussion in today's conference. At the same point in time, I should also appreciate the organizers for having best of the best legal experts from different corners of the world. I can find some of my good friends as well as colleagues as the part of actually this the conference. Ricky Lee, or maybe Elgar Sadeh, Dr. Kaur, then we have Banerjee. We have actually Professor Tyagi. All of them are actually the part of this particular conference. I should really congratulate actually the Kerala Law Academy for roping in best of the best experts in the space law. As the inaugural address, or sorry, as a keynote address to be very precise, let me just focus primarily in terms of the weaponization per se. I will carry forward from actually the previous 2 speakers and try to concretize in the context of the topic of this particular seminar. That's the reason why I have a PPT. So I'm trying to channelize my entire actually the presentation for the next 15 days, for 15 minutes, for focusing on actually the aspect of weaponization and how it is dealt under the Outer Space Treaty 1967. If you look into the scenario when the space activities started, it was the time of the Cold War. Both US and USSR were heavily involved in actually the Cold War. And the advent of space took place not for commercial purposes at that time, or maybe not even for scientific purposes, to be very precise. It was for strategic advantage. Both of them wanted to use it for some kind of a military advantage. And this has also been actually realized by the world community. And UN General Assembly started to pass the resolutions with respect to peaceful uses of the outer space. Common interest, rights of everyone in space and celestial bodies, all these principles have come into existence, and also primarily requirement of the peaceful uses has been highlighted. Soon the UN Corpus was also established, United Nations Committee on the Peaceful Uses of the Outer Space. And many of the developments in terms of the international lawmaking started to take place under the auspices of the UN Corpus. Since it also had a legal subcommittee, most of the debates or deliberations for the international law making in terms of peaceful uses started to develop in the UN Corpus. So it's very clear that since beginning, international community wanted to use outer space for the peaceful purposes. But if you look in reality, despite all these efforts and despite Outer Space Treaty 1967 coming into existence, I'll discuss the relevant provisions of the Outer Space Treaty a little later. Despite all these efforts, use of the outer space has not always been for only peaceful purposes. Even weaponization, there are different instances wherein actually the attempts were made for the weaponization of the outer space. If I have to quote certain major instances, starting from 1968, Soviet Union went for the FOBS, fractional orbital bombardment system, wherein they basically wanted to use the low Earth orbit for transporting the nuclear weapons. So a lot of research went on during this period, 1960s and 1970s. And fortunately, with the SALT II Treaty of 1979, the USSR actually agreed to stop this kind of actually the system. Almost by 1983, FOBS project was actually made defunct by the Soviet Union. Then we have got anti-satellite missile testings. During the Cold War, both US and USSR tested. Then subsequently, China did it in the 21st century. US tested in the very next year. India, again Russia. So different countries have actually tested multiple anti-satellite missiles. Strategic Defense Initiative, SDI, another significant instance of using the outer space actively for military purposes or even for weaponization for that matter. The United States declared this Strategic Defense Initiative, or popularly known as the Star War program, during the Ronald Reagan administration. 1983 actually it has been declared, and the plan was primarily to have the anti-ballistic missiles embedded in the outer space, maybe in their satellites or even in actually the celestial bodies. They had put forward this to the world community, saying that it is for defense purposes, because at the end of the day, it is anti-ballistic missiles. They are for the purpose of countering the ballistic missiles. So a kind of a defensive shield can be provided to the entire Earth was an argument of the United States, but how convincing is really debatable, since more than 7,000 scientists in the United States itself, including many Nobel laureates, went against the Strategic Defense Initiative program. So they went into the road in protest against the Strategic Defense Initiative. So whatever it may be, United States continued with the Strategic Defense Initiative until the collapse of the Soviet Union. But after that, what is the status? Nobody knows clearly about the Strategic Defense Initiative. So ASAT testing and the Strategic Defense Initiative are the two major instances of using the outer space directly for military advantage. In the recent period of time, we are finding the space warfare in a different manner. Instead of those kind of physical objects, we are finding now the laser attack, cyber attack, and maybe any other kind of actually the attacks without actually the physical objects. There are many instances of blinding the satellites, jamming the signals, and even actually the making the satellite to drift from the orbit. So different kind of actually the activities have been carried on with the help of laser technology as well as with the cyber attacks. So now the question is it that all these things are showing us a kind of a major threat to our future? Because if at all somebody actually takes or uses outer space for military advantage, there is every possibility of actually destroying, resulting in actually the large-scale destruction at the global level. So therefore, it is all pointing towards actually a wrong direction, wherein actually our future itself is greatly threatened. Now, in light of that, we need to look into the existing treaties, especially I'm focusing on Outer Space Treaty, which is considered to be the Magna Carta, and how exactly it is trying to deal with the weaponization of outer space. Right? Since the theme of this conference is in terms of weaponization or arms race, how is it trying to deal with it? If you look into the Outer Space Treaty, apart from Article 9, which Dr. Kaur has already pointed out, which is about the due regard the principle, we can find two other major provisions in terms of the demilitarization or de-weaponization. Article 3 and Article 4. Article 3 is more of a general provision because it says that all activities in outer space and celestial bodies should be subject to the public international law, including the Charter of the United Nations. So we cannot consider the space law as something completely distinct from public international law. It is an offshoot of the public international law. And wherever we are having the gap in space law, we can always revert back to the public international law, including the Charter of the United Nations, and we have got the justification under Article 3 of the Outer Space Treaty itself. So if we look into the developments in public international law as well as the UN Charter, it is very clear that there is a prohibition on threat of force or use of force and even armed attack. Provisions of the UN Charter are very clear, and even under the public international law, different treaties are entered into with respect to preventing the threat or use of force as well as the armed attack. Conference on Disarmament also carries this forward and categorically says that our peace, international peace and security can be maintained not by virtue of accumulation of the armaments, but by virtue of discarding them. So under the ambit of defensive activities or whatever other things it may be, accumulating more and more armaments is not going to actually help in any manner. Rather, it is going to actually make higher inroad into the threat to our future, rather than actually maintaining the international peace and security. So it's very clear that by virtue of Article 3 of the Outer Space Treaty, we can safely come to the conclusion that public international law is applicable, UN Charter is applicable, and whatever prohibitions are there under those treaties and UN Charter need to be respected also in the outer space. But unfortunately, most of the states, or maybe most of late, even the private entities, because they are also actually into the business of space weaponization as of now. That's a very, very scary picture. So even if you Google also, you'll be able to find out the different private companies who are almost the warlords who are basically actually making their business through weaponization. Anyhow, so those who are the violators of these principles always argued that Article 3 is more general in nature, that is under the public international law. Therefore, we have to look under the space law specifically for activities in outer space. So they have tried to evade their responsibility. I'm not saying that is correct. That is a wrong argument. We should bring it within the ambit of public international law. But unfortunately, they are arguing that we have to look more into the space law with respect to the de-weaponization or demilitarization. Now, in terms of the space law, specific provision is Article 4 of the Outer Space Treaty. Problem with Article 4 is that, number one, it has been drafted in 1960s, wherein many technologies were actually not developed, especially the military technologies were not developed. Number two, there is also a problem in terms of drafting. It has left out actually a lot of rooms for misinterpretation. That's also a problem with Article 4 of the Outer Space Treaty. Article 4 has got two parts. First part I have basically highlighted here. It says states parties to the treaty undertake not to place in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction, install such weapons on celestial bodies, or station such weapons in outer space in any other manner. There are certain portions which I have highlighted in red. I'll come back to this. Just before that, let me just point out one thing, that is about paragraph 2. Paragraph 2 of Article 4 speaks about the requirement of peaceful uses, and it also actually prohibits the testing of weapons, etc. But unfortunately, while drafting the paragraph 2, it misses out the term outer space. It says moon and other celestial bodies should be exclusively used for the peaceful purposes. And it also goes on to say that having the installation, fortifications, or testing of the weapons in the celestial bodies is prohibited. So the missing term outer space has resulted in actually the lot of arguments or the misinterpretations saying that there is no requirement of using outer space for the peaceful purposes. Again, incorrect argument. I'm not supporting this argument because if you can go back to the preamble of the Outer Space Treaty, it is very clear that there is a requirement of the peaceful uses of even outer space. It's not saying that peaceful uses shall be confined only to the moon and other celestial bodies. But unfortunately, that is not properly reflected under the second paragraph, resulting in a possible misinterpretation by the violators. Now, coming back to the first paragraph, right? So, which is there in the slide, which is on primarily on the weaponization or preventing the weaponization of the outer space in celestial bodies. There are two major limitations. One, if you look into the provision, it is very clear that there is prohibition only in terms of placing in orbit and stationing such weapons in outer space. Placing in orbit or stationing the weapons in outer space. It is not mentioning about testing of the weapons. Temporary presence. So that has not been specifically mentioned therein under Article 4 with respect to the prohibition, which has been used by many countries to say that anti-satellite missile testings are permissible by virtue of this. That is one of the limitations. Second limitation is in terms of the kind of weapons. If you look into the highlighted portion again, the one which is highlighted in red, nuclear weapons or any other kinds of weapons of mass destruction. It says nuclear weapons or any other kinds of weapons of mass destruction. So what is prohibited is only nuclear weapons or any other kinds of weapons of mass destruction. Many of the violators argue that whatever weapons which they are having or whatever weapons which they are actually carrying to the outer space are not the weapons of mass destruction. Even cyber attack or maybe the laser technology, whatever they are using, they are saying that they are not the weapons of mass destruction. So Article 4 prohibition is not applicable to them. So these are the primary arguments. Now, in the context of this, let me actually look into the definition of weapons of mass destruction. Right, so that has been debated in the UN General Assembly. Resolution 34/87A of 1979 provides this definition. Weapons of mass destruction are the automatic explosive weapons, radioactive material weapons, lethal chemical and biological weapons, and any other weapons developed in the future which have characteristics comparable in destructive effect. Of course, the first part is more in terms of atomic explosive weapons, radioactive weapons, or maybe chemical and biological weapons. All those kind of things are mentioned in the first part. But what has been missed out by many of the critics has been the last part. Any weapons developed in the future, it also speaks about future weapons, which have characteristics comparable in destructive effect. Destructive effect. So that is something very, very significant, and we have to go for a purposive and evolutionary interpretations. I say, first of all, if you can go back, it says characteristics comparable in destructive effect. So we have to go by the effect of the particular weapon. How effective is a weapon? How much destruction it can cause? A purposive interpretation of this with respect to Article 4 would clearly indicate that we have to distinguish our interpretation on earthly basis from the outer space. Because what is mass destructive on the earth is not something same as that in the outer space. Situation is entirely different in outer space. When there is a possibility of a small space debris of 1 centimeter capable of destroying a medium-sized satellite of 5 to 6 tons. A small debris of 1 centimeter is capable of destroying a satellite of 5 to 6 tons. One can imagine destructive effect in outer space is entirely different from what we can find on the earth. Right? We have a different scenario. The velocity with which the object travels there in outer space is uncomparable on the earth. Right? So given that particular factor, we have to interpret this destructive effect in light of the outer space scenario rather than confining ourselves only to the earthly scenario. So we cannot say that only biological or chemical weapons or radiological weapons are prohibited. Rather, on the basis of destructive effect, we have to find out which are the weapons which should be prohibited in outer space. That's number one. Number two, evolutionary interpretation. That is in terms of actually the modern so-called weapons, laser technology or maybe cyber attack, etc. Those who conduct it, they will simply say that there is no weapon, there is no tangible object. So how do you classify this as a weapon of mass destruction? How do you say that there's a use of force or there is an armed attack when the physical object is not there? How do you say that? Again, let me go back to the previous slide. The last part, any weapons developed in future which have characteristics comparable in destructive effect. Please note, it does not mention any physical weapon developed. It says any weapons developed in the future which have characteristics comparable in destructive effect. So whether it is tangible or not tangible, at the end of the day, on the basis of the effect of the concerned weapon, one has to classify it as a weapon of mass destruction. So if the laser technology or maybe the cyber warfare results in actually the greater level of destruction, right? So it is equivalent to that of actually the mass destruction. Ultimately, we have to qualify this as weapon of mass destruction, or at least we have to consider this as a use of force or armed attack contrary to the public international law. We can also find the references in the recent developments, the Tallinn manual of 2017 and the Umera manual of 2018 on the international law of military space operations. Both of them clearly indicate that the cyber attack is a use of force, right? That constitutes use of force, and it is against the sovereignty, and also it is against the principle of non-interference against the, under the Charter of United Nations. So therefore, we have to qualify all these things on the basis of effect of the concerned object or the weapon and consider them as something prohibited under Article 4 of the Outer Space Treaty. Finally, I would also like to say that our original purpose of using the outer space was for peaceful purposes. Right? So entire things developed on the basis of the peaceful uses. That was the very reason with which actually we have proceeded with the lawmaking with respect to the outer space activities. Whether it is defensive or offensive, at the end of the day, both of them would not qualify as peaceful. Even if you actually develop a weapon which is for defense purposes, saying that it is for defense, it would not qualify as a peaceful use. As Judge Vladimir Varshishin says, semantic methods cannot transform a military activity into a peaceful activity. Whether it is defensive or offensive, it cannot transform a military activity into a peaceful activity, and vice versa. Peaceful would not transform into the military. In any language, peaceful activity remains peaceful and military. So this we have to understand, and we have to actually give a wider interpretation to Article 4 of the Outer Space Treaty and ensure that outer space is not used for any kind of a weaponization or anything which would threaten the maintenance of international peace and security. That's all. Thank you so much.
Thank you, sir, for providing us with your views.
Thank you.
Now, joining us for a special address, we have Dr. Banerjee Shaka, Professor of International Law and Dean at the VIT AP School of Law, VIT AP University, Vijayawada, Andhra Pradesh. He was a British evening scholar at the School of Oriental and African Studies in the year 2015 to 16. He has built his teaching career at numerous colleges, including Alliance School of Law, Alliance University, Bangalore, Symbiosis Law School, Hyderabad, and National Law University and Judicial Academy, Assam. I invite Sir to deliver the special address to share his deep knowledge and expertise. Sir, please.
Thank you very much, and good morning to all of you. Particularly, I take this opportunity to thank the organizers, particularly the Kerala Law Academy. And if I trace my association with the Kerala Law Academy, in previous years, I had an opportunity to visit Kerala Law Academy 3 times. And Kerala Law Academy has one very important milestone, that conducting conferences, conducting faculty development programs in the niche areas of international law. In the last 3 occasions, I had participated as a resource person, as an expert of international humanitarian law, and interacting with the then students. I think it's almost maybe a decade back. Now, when a student from the Kerala Law Academy has communicated with me that, sir, we are conducting the 16th edition of International Conference and Seminar on Space Law, that to weaponization of outer space, then I cannot say no to it because of these reasons. because I appreciate Kerala Law Academy for doing the wonderful job of dissemination of international law and conducting this kind of programs on niche areas of international law. I take this opportunity to congratulate and thank the director, the principal, and other faculty members, particularly Professor Anil Kumar sir and other members for giving this platform to us. And I do take this opportunity to thank our speakers. Today we have a galaxy of speakers before me. Dr. Ranjana Kaul madam, and she eloquently set a tone for that the background of the outer space and the measures which led to the outer space militarization. And subsequently, we have none other than the director of Vikram Sarabhai Space Station. He has given a very good, wonderful ideas, and he is a practitioner of a space law, and he spoke very good. And now coming to my good friend Professor Sandeep Abad, he has really touched upon all those aspects which I don't have much to say anything on that. But however, since I have the knowledge of both the domains of international space law and international humanitarian law, I'm going to speak maybe a few minutes and see how this militarization of outer space has a close nexus with international humanitarian law, because that is where I do my research. Generally, the space militarization and weaponization and its impact on international humanitarian law, and what are the humanitarian consequences of weaponization of outer space. This is the topic which I'm going to deal in coming few minutes with the wider audience we have. So if you look at this particular idea of outer space, we all know that it is an internationalized common area beyond the national jurisdiction of individual state, and the security in space must be the common security of all states. So based upon that, this particular space law legal regime is primarily developed in the midst of this Cold War period. And like what Dr. Ranjana Kaul ma'am has said, and the kind of energy which international actors had during that particular time, the 5 conventions and other aspects have simultaneously negotiated, and they came from 1963 to 1972. In the span of 1 decade, we have a lot of space legal mechanisms. So, however, in the kind of mechanisms which we have, during the Cold War and the post-Cold War era, setting a kind of confrontations with regard to the appropriation of the space, outer space resources by the space powers, now they led to a kind of an asymmetric interest in the space, particularly in outer space. And now that is also facilitated the commercial operations and also the private actors' involvement in the space assets and space activities. And this causes a kind of major disconnect between the states when they approach to the negotiations table. Specifically, the states, while seeking to normalize their relations, they're also eager to either to preserve or deconstruct the asymmetric power structures which are there in the outer space, and it's kind of situation. Now, if you look at that, the kind of after adoption of this space policies and space law treaty mechanisms, now they are several decades old, and now we have them emerging issues beyond the effective management of the current space law. Now, in the midst of all these things, now the space law maybe is driven by, should be supposed to be driven by the 4 important main factors. That is, the technological developments which are emerging right now. And the second important thing is that the increased capabilities of specifically the states, how they're trying to use the technology to undermine the existing, the legal regime and the normative state practices of international law within the outer space. And also which another aspect is commercial space activities. And finally, how the commercial, the weaponization is contesting particularly the spacefaring nations and peaceful activities of the outer space. Now, if you look at that, the statement which made by our Professor Sandeepa Bhatt, and he ended there is no negotiation in the space law that it must be peaceful uses and peaceful purposes, and the state-faring nations must support the activities of the space with regard to that. Yes, I totally agree. And it is an eloquent message what we all have to understand with regard to it. But however, having said that particular important principle, but now the recent creation of US Space Force and NATO's declaration on the space, they declared that it is a fifth operational domain along with the land, water, air, and cyberspace. And it has once again a kind of sparked a debate regarding the militarization of outer space. Look at that and how the states and even the organization like NATO is declaring outer space is a domain of not like any other space, what we are calling under the Outer Space Treaty as a common heritage of mankind. They are not saying that it is no more. It is a kind of space where we are interested to be proclaimed over there. So now when you are looking at such kind of statements given by the states like China, India, Russia, and they are also developing a new space capabilities to achieve military goals and reduce the reliance on the US space system through various military reforms. Now we have seen that China's ATST and also India's capabilities of joining in the league of elite group of anti-satellite missiles. They used it and they did the exercises. We have seen that one. And Russia also have organized a new military force which is devoted to the employment and deployment of space, counter space capabilities, which they are regularly integrating them into the military exercises. This is a very alarming. So when this kind of an alarming situation, now how are we going to address the problems what we have? Now we know that anti-satellite missiles destroyed their target satellites. And when China did that exercise, more than 300 pieces of space debris, which emerged out of that particular destroying of one of the China's defunct weather satellite. And now they continue to pose a threat and they continue to be there for decades on the outer space. This kind of counter space directed energy weapons which are designed to produce a kind of reversible or non-reversible effects against the space system, the kind of highly emitting focused radio frequency or laser energies, now it is a kind of status of affairs where we are. So now, in this particular context, as a student of international humanitarian law specifically, or a student of space law, we should look at that, look at how it is going to create a rift among the states and use outer spaces. So far, we have considered that as a peaceful purposes, we should use it, and for the common heritage of the mankind, we should use it. But now, what could be the humanitarian consequences? Let us focus for a few minutes on that. The potential humanitarian consequences of the use of the weapons in outer space is they would disrupt, damage, destroy, and disable the civilian or dual use space object could entail a range of humanitarian consequences. By physically damaging or destroying the space objects could generate a huge amount of space debris, what we have seen, which could in turn damage or destroy in an unpredictable manner the other space objects such as communication and weather satellites, and which are supporting the safety of the critical civilian activities and essential civilian services on Earth, which are functioning during the time of armed conflict and otherwise during the time of natural calamities and disasters. That's a greater threat which is opposing. Now we have the second point here, the disaster prevention and mitigation mechanisms. For example, evacuation or other measures which are anticipated during the time of natural disasters. They also be seriously affected if weather satellites are disabled or damaged due to that increasing militarization and weaponization of the space. So in addition to that, the satellite phones which are used by the humanitarian organizations and humanitarian workers and the medical personnel to communicate in times of emergency, particularly times of natural disasters and armed conflict. When the mobile phones are not in use, they're completely creating a devastation and posing a threat to the lives of the people and causing a greater disaster in the humanitarian operations. So in this respect, the disruption of the telecommunication services provides a kind of hindrance to deliver the humanitarian assistance and emergency relief that are completely based upon the satellite technologies and satellite phones. Now, the third point is that civilian vehicles. We have the civilian vehicles, shipping and air traffic controls. They're increasingly relying on the global navigation satellite systems. They also may be used by the military and potentially making the system are defunct, are disabling, are damaging such kind of navigation satellite through the kinetic or non-kinetic means could have a wide-reaching consequences for the civilians on Earth, not only in the time of conflict and natural disaster, but also in the time of peace, like what we are using. Now, what are the existing limits for the military activities in outer space, particularly under the international humanitarian law? Let's look at that international humanitarian law, what it says. The military uses of space objects have for several decades been an integral part of the contemporary warfare. For example, if you see that the armed forces, they rely, as I mentioned earlier, they rely on the satellite navigation system to enable the precision navigation and the targeting attacks. And through that GPS system and the satellites to enable the global communication. And they also have the command and control. And this kind of space-based monitoring system allows advanced warning of missile attacks and surveillance and other reconnaissance mechanisms. So as the role of the space systems in military operations, so since we are increasingly using that one, and there is a likelihood that the system will be targeted, whether it is either in the ground or space component, or the link between them, which also increases a potentially significant consequences for the civilians outlined in this kind of thing. So in this context, if you look at that in 2019, if I remember very well, in 31st of January, a group of government experts, the chairperson of the group of government experts, and in his report, he said that there is a possible threat to the space system can be classified in order of growing the intensity and ranging from the electronic warfare, cyber attack, or directed energy attacks, or to orbital-based anti-satellite system and ground-based anti-satellite weapons. They all will have adverse consequences on the lives of the civilian population. So whatever the military activities occur in outer space, such activities are constrained by the existing international legal mechanisms of what we have, that is, both under the United Nations Charter, Outer Space Treaty, and international humanitarian law. And our friend, Professor Sandeep Bhatt, has already mentioned that use ad bellum, the use of force. If you look at that in the United Nations Charter, Article 2, Clause 4, which classically defines the use of force in international relations. Now, can we say that space is given any kind of exemption from the application of this particular Article 2, Clause 4? No. What we consider that in any relations, whether it relations belonging to the states in terms of the aviation or space or humanitarian law or any other relations, Article 2, Clause 4 of the United Nations Charter has been directed. States must not use, it's a jus cogens principles, a peremptory norms of international law. So hence, the state must be directed towards application of those principles of the jus cogens principles of international law, which are specified under the UN Charter in accordance with Article 2, Clause 4. That's the first kind of principles which we'll have to look at it. The second important point, which I would like to say in the terms of the treaty mechanism, the Outer Space Treaty, as elucidated by our friends in the particularly Article 4, which prohibits the placement in the orbit objects carrying on the nuclear weapons or other weapons of mass destruction, or installment of such weapons on the celestial bodies and stationing of the such weapons in any manner is inconsistent with the principles of international law, particularly the Outer Space Treaty. Now, thankfully, we have 2017, the United Nations Convention on the Prohibition of the Nuclear Weapons, which came into force. That is also prohibits the use of the nuclear weapons in the international relations. Now, as an application of this particular principles to the outer space, definitely we must apply those rules and try to reduce the kind of effects and militarization of the outer space. So these treaties forbids the establishment of the military bases, installation and fortification, and the testing of any type of weapons, and the conduct of military maneuvers on the celestial bodies, which requires that they should be used solely for the peaceful purposes. So I would say that this is a kind of one of the norms of international law. Now, the last and third part of my presentation is that application of the IHL principles in outer space. The applicability of the IHL in outer space is confirmed by the Article 3 of the Outer Space Treaty, which says that international law applies to the use of outer space. That means the public international law is, which is including the international humanitarian law. We cannot dispense with use in bello. Use ad bellum, that is in the United Nations Charter, Article 2, Clause 4, which specifically prohibits the use of force in international relations, must be applied. Then in the same note, what I would like to say that use in bello, that is international humanitarian law, the law regulating the conduct of the armed conflict of the state parties, if it affects the outer space, that must be limited by the principles of international humanitarian law. So it is important to establish that particular IHL, and that you should apply the rules on any military operations which are conducted in the context of the armed conflict, including those who are occurring in the outer space, regardless of whether they are resorting or not resorting the force that triggered the armed conflict, which is considered as prohibited under international law, UN Charter. Here, one point I would like to say that the IHL does not legitimize the use of force in outer space, nor its militarization or weaponization. So, in conclusion, it says that the sole aim of the international humanitarian law is to preserve a measure of humanity in the midst of the armed conflict, notably the protected population and its protection of the civilian and other protected categories of the people by employing the measures which are there under the international humanitarian law. To conclude, the IHL forbids any kind of installation or stockpiling or targeting by using the outer space through the civilian objects is completely prohibited. The civilian satellite or some of their payloads may also serve the armed forces, and hence they are having the dual use of the nature. And now they may become the military objectives. They provide that, use for the military sources. If you look at that Article 52, Clause 2 of the Additional Protocol 1 of the International Humanitarian Law Treaties, that is Geneva Convention, specifically prohibits and disabling such kind of mechanisms which adversely impacting on the civilian population. So the IHL limits, prohibits the indiscriminate and disproportionate acts when they are taking and all feasible precautions and the choices of means and methods of warfare to avoid any kind of harm to the civilian lives and civilian properties and civilian objects. So this is what international humanitarian law specifically directing towards this. And even debris also. The debris may continue to travel in the orbit, and they are produced because of the kind of attacks which have been taken place. Now, given the speed which they travel, debris risk damaging with other satellites supporting, particularly the civilian activities and civilian services, must be brought under the rubric of international humanitarian law. This would have to be considered when we are assessing the situation under the limitations of means and methods of warfare in the outer space. So I think this is what exactly we need to invoke the existing principles of international humanitarian law in consonance with the public international law, the principles of international law which are elucidated in Article 2, Clause 4, and other principles in order to prevent militarization and weaponization of the outer space. With this, I thank you so much for the organizers giving me an opportunity to share some of my thoughts. And I always ready to answer if you have any questions in this regard. Thank you so much.
Thank you, sir, for providing us with valuable insights through your special address.
Gratitude unlocks the fullness of life. It turns what we have into enough and more. So now we will have a young and vibrant Seren Elsa John Ma'am, Assistant Professor at Kerala Law Academy Law College, who will present the vote of thanks, expressing our gratitude to all the contributors and participants. Ma'am, please.
Respected Director of International Institute of Space Law, Dr. Anjana Ma'am, Director of VSSC and Director of IIST, Dr. Unnikrishnan Sir, invited guests on the panel, Dr. Sandeep Bhatt and Dr. Benarji Chaka, Principal of Kerala Law Academy, Professor Harindran Sir, Director Administration, Student and Faculty Affairs, Professor Anil Kumar Sir, Vice Principal Anil Sir, Associate Professor Ajita Ma'am, Assistant Professor Dr. Dakshina Ma'am, teachers, students, research scholars, members of the legal fraternity, other members of the audience, a warm and cherished morning to you all. It is a matter of pride for me to propose a vote of thanks at this inaugural session on behalf of the Kerala Law Academy at its 16th International Seminar on the topic, Role of International Law in Controlling Weaponization and Arms Race in Outer Space. Outer space has always intrigued me. It's indeed exciting to explore the application and extent of laws that govern the outer space. I offer my sincere gratitude to the eminent and highly respected scholars and law professionals who have contributed their valuable insights on this very interesting and widely discussed area of space laws. Dr. Ranjana Kaul is a highly respected litigator in the field of air and space law. Her knowledge on the subject, her ability to connect with the audience by discussing contemporary issues on this area, and her passion for this subject shines through every time she speaks. Thank you, ma'am, for being a mentor, for taking time to share your knowledge and thoughts here with us, and for delivering the presidential address. It is truly an honor to have in our midst Dr. Unnikrishnan Sir, who shared his profound thoughts on the subject. In addition to being a renowned scientist with the VSSC, when I learned that Sir has an MA degree in space law, I was more than curious to know his views on this subject. We thank you, Sir, for agreeing to be part of this seminar, for taking time out of a busy and tight schedule for delivering the inaugural address. Dr. Bhatt and Dr. Chaka are two renowned academicians in the field of space law. Their research on this area is wide, well known, and well published. We are privileged to be part of your audience, sirs. Thank you, professors, for sharing your work with us.
It's a pleasure to be part of your conference.
Thank you, sir. I take this opportunity to extend my heartfelt gratitude to Advocate Nagraj sir, Director of KLA and Member of Bar Council of Kerala, the Principal of Kerala Law Academy, Professor Harindran sir, Professor K. Anil Kumar sir, Director of Student and Faculty Affairs, Kerala Law Academy, who are the visionaries of the Academy and have supported us every step of the way to make this international seminar possible. Thank you, teachers. I extend my deepest gratitude, Dr. Dakshina Saraswati, for working tirelessly to make this seminar happen. Thank you, ma'am. I thank my fellow conveners and members of the organizing committee, Professor Anil Kumar sir, Professor Ajita Nair ma'am, assistant professors Sri Shakti and Sri Sajid, and student convener Arya, who were instrumental in planning and executing every detail. Lastly, but most importantly, the technical team of Kerala Law Academy, the student coordinators, the teaching faculty of Kerala Law Academy, research scholars, students, law professionals who have contributed papers, students of Kerala Law Academy and other institutions. To them, I extend my deepest and sincere gratitude for their kind attendance and cooperation. Thank you very much. Thank you.
Thank you,
Thank you,
Thank you
Saran
so
ma'am.
much.
Thank you, Saran ma'am, for your words of gratitude.
As
Thank
we
you
come,
all. Thank you all, and Sharon mostly for connecting with me. Thank you.
It's a pleasure to have you, ma'am.
So, as we come to the end of this remarkable session, it is essential to express our heartfelt gratitude to all those who made the session remarkable. A sincere thank you again to all of our esteemed guests who graced this session with their insights and experience.
A special word of appreciation goes out to faculty conveners, teaching, non-teaching, and administrative staff members who have contributed their time and efforts to make this event a success. Lastly, we would like to express our deep appreciation to all the participants who have taken the time to attend this event.
Also, we would like to thank each one of you for being a part of this event. Your presence here today enriches the overall experience and motivates us to continue organizing such knowledge-sharing platforms in the future.
With that, we have officially come to the end of the inaugural session of the 16th International Seminar organized by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research and IQAC KLA. I encourage all participants to actively engage in the upcoming sessions and make the most of this opportunity to deepen our understanding of the role of international law in outer space.
We extend a heartfelt thanks to all of you for sharing their expertise and valuable insights. Once again, thank you all, and I request all of you to join the valedictory session scheduled at 4:30 p.m. IST today. This is Iron Elsa Charian
and Gauri Sevi signing off, wishing you a productive and enlightening seminar.
Thank you all and have a wonderful day ahead.
Thank you. Have a nice
Thank you.
day.
Thank you.
all, and wish you
Thank
good
you.
luck for the seminar.
Thank you, sir. Thank you.
Thank you, sir.